May I pray, my lord, a listing for tomorrow or day after tomorrow?
Tomorrow, if it's possible, get it listed. Tomorrow.
Obliged.
May I please, Your Lordship?
Yes.
My lord, we have been running a market since 91, my lord. And accordingly, my lord,
What
recently.
is your prayer? Don't go to the facts. What is it?
Yes, my lord. For listing of this case that was filed on yesterday, well, there is a
Motion.
prayer. Yes, my lord.
Motion is when?
Yes, but tomorrow, my lord.
Okay.
Deeply.
May it please your lordship. I beg to mention item number 13, lordship.
1-3, yes.
An adjournment slip was furnished, lordship, in connection with the item,
Matter of 17.
lordship.
Adjourn-
Kindly, lordship, 2 weeks, lordship.
Why? 17 matter?
Lordship, Mr. Bordolo is out of station, lordship.
Sorry. No adjournment of 17 matter.
Can it be an?
No adjournment.
Take up.
No adjournment.
Lordship.
At least not at this stage.
Lord.
Motion. I have mentioned. Let it reach
May it please your lordship, I beg to mention item number 12.
12. Yes.
Lordship, on behalf of the petitioner, lordship,
Yes.
we have taken consent for the other side. Lordship, the main engaged counsel, lordship, due to some personal difficulty.
Rejected. 16 matter. Sorry. Yes.
Lordship,
Rejected. 16 matter. No adjournment.
May it please your lordship, may I beg to mention item number 3 of the daily list.
Yes.
Hearing the conducting counsel, Mr. R. Sharma is out of station and for which the matter may be adjourned today, your lordship. We have taken the consent from the other side. It may be taken up in the next week.
We'll have it on Thursday.
Thursday.
Yes.
Yes,
Day
sir.
after tomorrow.
The affidavit has to be filed from our side, Your Lordship.
You have to file affidavit.
Yes, yes.
Not yet filed.
Not yet filed because we are in receipt of copy, Your Lordship.
While a prayer for adjournment has been made on behalf of Sri R. Sharma Learned Counsel for the petitioner, Sri R. Gogoi Learned Standing Counsel, Forest Department has prayed for time to file affidavit in opposition. Why haven't you filed 23 matter till now?
Recently, they have an additional affidavit, Your Lordship. We have received
Um,
the drafted. We have sent it for vetting, Your Lordship.
Matter accordingly stands adjourned by 2 weeks to enable filing of such affidavit. Full stop. List on the process now. 2 weeks will be. We'll have it on 11th of September.
Very well.
I'll have this.
File it.
Obliged.
11/9. Yes.
Hey, please, your lordship. Lordship, I beg to mention two WPC matter for listing in orders column, lordship.
Orders why?
Lordship, it's a land acquisition matter.
What is the urgency?
Lordship, it was last listed on 2025.
No, what
was
is the
supposed to
urgency? Matter of which year?
2025.
Sorry, the other one?
Sir, lordship, same.
You apply before the registry. For mentioning, it has to be an extremely urgent matter.
Obliged.
Accept motion. Yes. Yes, what is it, madam?
Your lordship, the petitioners will not like to press this issue.
Not like to press.
Would like the instructions from the petitioner.
Not to press. Irrigation? You're for irrigation. And finance? Anyone? Finance? Who's there at the court today present? H. Alia, is he there, or Mr. B. Gogoi? What is your name?
Lordship S. Barua,
On behalf of whom?
KB Pathak.
Miss S. Barua, Learned Counsel, appearing on instruction of Sri K.P. Pathak, Learned Counsel for the petitioners, has submitted that there are instructions from the clients not to press this writ petition. Full stop. Also heard Miss G. S. Neug, Learned Standing Counsel, Irrigation Department, and Miss and Sri H. Alia. Mr. Chalia, Finance, H. Alia, Learned Standing Counsel, Finance Department, para. Writ petition accordingly stands dismissed as not pressed. The other one, madam?
Your lordship, both.
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 Separate orders, huh? দুটা একেই petitioner, এটাই order দি দিব পাৰিব নেকি? ওপৰত নাম লিখি পেলাই। Petitioner টো তাকে petitioner এটা petitioner যে আছে নিউ। Okay. And Item 4, Mr. D.M. Nath, S. Dutta. Mr. S. Dutta, who is S. Dutta? D.M. Nath. council, Mr. Titia? Who are the council? S. Dr. DM Nath. Not him. Not him, not Mr. S. Das, S. Dr. You're for SIDC, Mr. Das?
And for ASID,
Affidavits filed.
pleadings completed.
Where is the council? None appears for the petitioner, petitioners on call, whereas Sri M. Chetia, Learned State Council, and Sri S. Das, Learned Standing Council, ASIDC, are present. Para, in the interest of justice, matter is adjourned to be listed on Friday next.
Until 5.
Please, Your Lordship. The matter pertains to appointment of a rural retail outlet dealership under the HPCL. ma'am.
You can have it for disposal today.
I am arguing for disposal.
Mr. Botakur appears for whom?
HPCL.
SPC. And Mr. Ahmed for? R6. And who else? Yes. Okay. Yes, Mr. Bharadwaj, what is it?
The advertisement is of 28th of June 2023. Now,
Page?
I've given a type copy, my lord, at page 22,
23.
22B, annexure 1. 22B.
Yes, what is it?
Now, the advertised location is serial number 266 between Ancholik Jatiyo Bidyalaya Ramdia to HS Ramdia School at Ramdia.
266.
266. Now, it's a rural retail outlet, my lord, and under SC category. And the dimensions are mentioned as 30 meters by 30 meters, 900 square meters. Now, the petitioner applied, and since he didn't have any land to offer, he, along with similarly other similarly situated candidates, were placed at group 3. That means the candidates who doesn't have any land to offer. The private respondent,
Yes.
he offered a plot of land, and before that, one another candidate was rejected because of the land scenario. He was again placed in group 3. The private respondent
Group
was
C or D?
3, 1, 2, 3.
You are 3.
I'm 3.
Those having no lands of their own is group 3.
Yes,
Roman 3 or normal 3?
normal 3, man.
Okay.
Numerical. The private respondent was placed at the group 1 because he gave
Private respondent number
private respondent
6.
6.
Mr. Ahmed's client, yes.
He was placed at serial number 1,
Group 1.
group 1, because
He had land.
he offered a plot of land as per group 1 category. He offered a plot of land through long-term lease with minimum 19 years, 11 months. So he offered a plot of land with a registered lease deed of 30 years.
Mm. Yes.
Now, I'll just take your lordship to the relevant portion of the guidelines, my lord, at
Yes.
page 37. This is the dealership selection guideline
তুমি যাবো
over
পারো মালিক।
that particular
অলপ পিছত
advertisement.
আহিব পাৰে।
And
20 minutes, minimum 20 minutes. Page 37, what?
Page 37, that is clause 4(6). Your lordship will see Roman small 6, land.
Land.
Group 1. I'm concerned with only group 1, challenging the selection of the private. Applicants having suitable piece of land in the.
But you say you do not have a land of your own.
I didn't.
You fall into group 3 category. There would be other contenders in group 1.
No, he's now the only one. He's now the only one. If he is, if his land is rejected, he will again be placed in group 3 along with us, and there will be a fresh draw of lots.
What about group 2?
My lord,
What about group 2?
there is no candidate in group 2.
There was only one candidate in group 1.
2 candidates, one already rejected.
One rejected.
Already rejected. He was placed in group 3. Now only the private respondent remains in group 1.
And that rejection is not the subject matter of any challenge. So that rejection has attained finality. So this private respondent remains as the lone candidate in group 1,
Yes, ma'am.
which you are putting to challenge.
Yes.
If you are successful, he will be placed in group 3
3 and there will
and
be,
at par.
yes,
Then there will be draw of lots.
yes. And again, we have to offer a plot of land aside from this plot, if there is any.
What did you give? You did not have any.
No, under group 3, we are not required.
Not
We are given
required.
certain time if
Yeah.
we are selected to provide a plot.
If there are no candidates under 1 and 2, then your turns come to you provide for a land.
Yes.
Okay. Now what is
Now
it?
group 1,
4,
applicant
6.
6, Roman 6, 4(6). Applicants having suitable piece of land in the advertised location area, either by way of ownership or long-term lease for a period of minimum 19 years.
6, which group?
Group
1.
1, man.
Okay. Please read again. Applicants.
Applicants having suitable piece of land in the advertised location area, either by way of ownership or long-term lease for a period of minimum 19 years, 11 months, or as advertised by the OMC. Now,
OMC means?
the oil marketing company. So he submitted a registered lease deed of 30 years. Now your lordship would kindly come to subclause A at the very bottom of the page. The land should be available with the applicant as on the date of application and should have minimum lease of 19 years and 11 months as advertised by respective oil company from the date or after the date of advertisement, but not later than the date of application. If the offered land is on long-term lease and there are multiple owners, then lease deed should be executed by all co-owners of the offered plot. This is my case, ma'am. In case lease deed is not executed by all co-owners, such lease deed shall be treated as invalid. So in one particular patta, if there are 2 or more dags, or let us consider one particular dag, and there are multiple co-owners, he is required to submit either an NOC or all the co-owners are required to execute that particular lease deed. That is the interpretation.
Yes.
Now, the persons from whom he took the lease, they bought it from their own father. I will show that, madam. So that for that particular reason, I'll just place the definition of family in front of your lordship. At page 38, the last clause G. The land owned by the family members will also be considered as belonging to the applicant, subject to producing the consent letter in the form of affidavit. That is another sort of a NOC from the concerned family members.
No, here he is not having a family land, is
He
he?
might take that stand, my lord. So before he takes
No, is it a family land?
yes, the person from whom he took the lease, those 2 persons bought that particular piece of land very recently from their own father. So my case is the father didn't give an NOC because he's a co-partner. That is my case. Such consent letter in the form of affidavit should have been tendered by the concerned family members on or before the date of application. Now, the power of the oil marketing company, that is HPCL, to reject such candidature, that power, lordship, I would like to place in the guidelines itself at page 41. The last clause of the guidelines. Page 41, note 1. 41.
Yes.
Page 41, note 1. A. The definition of own.
Hmm.
Own means having ownership by way of registered sale deed, registered gift deed, or title by property or registered long lease as per individual OMC norms in the name of applicant, family members as defined under clause 4.6 and 6H above. Now, my lord, I'm sorry, my lord, note 3 at the very next page. I'm sorry, note 3 at the next page, page 42.
42.
42, 42.
Yes.
Note 3. In case after selection, if it is observed that the offered land is co-owned by multiple persons and the provisionally selected candidate did not provide consent of all the co-owners, the provisionally selected candidate would be given 21 days time to get consent of all the co-owners for the offered land, failing which candidature of the provisionally selected candidate will be rejected. Now, the second Roman small 2, my lord, consent letters in the form of affidavit of a date which is prior to date of application shall only be considered. So he will be given a chance, but that particular NOC or affidavit is required to be predated to the last date of submission of application. And for that purpose, I'll just place before your lordship that particular date. The last date of submission of application was 17/10/2023. (17/10/2023) was the last date of submission of application. No, কৰি দিলে দেখোন ওলাইছে। 17/10/23. Now the lease deed, your lordship. The lease deed starts at page 69. 69. 69A is the name of the parties. My lord, page 69A. Pranab Jyoti Deka and Konok Deka. Both are sons of Soneshwar Deka. They executed this particular lease deed along with Ajoy Chandra Das, that is their private respondent, my lord. And this is for 3 kotha 10 lechas and for 30 years. Now there, I have taken multiple stands in the writ petition, but I'll be sticking to this particular stand only. And going by that, lordship would kindly come to the additional affidavit filed by HPCL, bringing on record that the additional affidavit filed by HPCL, which is dated to 2nd of April 26.
A page.
Page 168, it starts, my running page. 168 comes up. But here they have bought on record at page 172. Additional affidavit in addendum to the affidavit in opposition of the SPC. 172, man.
By whom?
By HPCL. They have bought on record. HPCL has bought this on record. No?
Page?
172.
The petitioner has filed a additional affidavit, being not record the Jamaabandi. Against that, my lord, we have.
No, we need the
Running page
page.
is 172, man.
Pages. This is what?
This is the annexure.
Pages are not matching, Mr. Bharadwaj. 168 is an affidavit and opposition by 1 and 2.
Yes, that particular document.
Yes. At 168, and where is it?
172, annexure A,
172.
annexure E.
এইখিনি কেনেকে দিছে চোৱাচোন 167 ৰ পৰা কি আহিছে ইয়াতে 174 আহিছে নহয় ইয়াতে 167 ৰ পৰা 174 আহিছে আৰু এইখিনি 168 ইয়াতে আহিছে 168 you want us to go to 168
168, there's one annexure in the.
160 is the affidavit in opposition by 1 and 2.
Yes.
What is there?
The annexure A is the opinion which HPCL obtained.
Annexure A.
A.
Annexure A is
This is by to the chief regional manager,
Okay.
HPCL.
it's by an advocate.
Yes. This is the opinion they obtained from their panel council over the plot of land. That panel council is now representing the private respondent.
Yes.
Now, the second last para, my lord.
Panel counsel is representing private respondent.
He's on the record.
Anyway, my lord. But this one particular.
Are you required to plead any other ground?
It is on the record, my lord.
Hmm?
I brought the original record with me.
Yes, thereafter.
Now, this is the document which HPCL relied on over the particular
Okay, we'll just go into the merits nonetheless. It's not proper at all. We don't, we really deprecate, but we'll go to the merits.
Now, the second last para of this page, my lord, annexure A. On perusal of Jamabundi. On perusal of Jamabundi of KP Patta 500 of Revenue Village, Majorpuri, it found that in offered dark number 1305, which is the dark taken for lease, there is total land measuring 3 bigha, 2 kotha, 5 lecha, presently recorded in the name of 7 pattadars owners, and out of which 1 pattadar Sri Soneswar Deka had sold his share of land measuring 3 kotha, 10 lecha to present landowners Pranab Jyoti Deka and Konkon Deka by registered sale deed number so-and-so dated 3/4/21. That predates the advertisement, my lord. And their names were duly mutated in Jamabundi White Mutation Order dated 18/4/2021. That also predates. As in the offered DAG 1305, total land measuring 3 bigha, 2 kotha, 5 lechas, jointly recorded in the name of 7 co-pattadas owners, but both the lessors and landowners have clear and specific land share of land measuring 3 kotha, 10 lecha with demarcation. This is the wrong opinion, man. With demarcation and separate boundary by registered sale deed. Now that sale deed was registered, we find 2021 names mutated, that is also fine. But demarcation never took place. So everyone remained a co-pattada, co-sharer.
This is your statement of fact.
No,
Demarcation was not done.
I have brought the Jamabundi on record. I have brought the Jamabundi. It's shown that demarcation has been done recently after filing of the case.
But what is the satisfaction to be derived by the HPCL?
HPC
That the land is first the prime objective. It is not encumbered.
Yes.
There is no dispute or ambiguity with the
There-
title.
Madam, there might arise a dispute provided you have not taken the consent of the co-sharers. ma'am.
No, the co-sharer will come when their co-sharer in respect of the property in question. This property was sold by a registered sale deed.
Yes.
It was, their names have come into the Jamabundi.
Yes.
Now we are not on the Jamabundi, we are mainly on the
Now,
sale deed.
now in that
the-
plot of land,
Yes.
we know in 3 bighas of land, do we know that towards the south or towards
They will know.
because it's not demarcated.
Who are you to question?
Well, the settled principle of law, my lord,
Who
I'm
are you
sure
to
from-
question? Who are you to question?
Well, I'll just
There might arise a dispute, but if they are satisfied, HPCL, it is not a question between an interested dispute of you and Mr. Ahmed regarding some properties of you and him. It's a satisfaction to be derived out by the HPCL with regard to the land which has been leased out. Can you bring out these kind of minute things to influence their the arriving of their satisfaction?
My lord, what my case is that
You have
they
to make out
depended-
a clear case that this is a violation of the conditions.
Yes. So what
Now,
this
we
court-
thought that the lease, it was procured later on or sale deed later on. Everything was earlier,
my lord, what this court
only
interpreted,
because of the demarcation.
well, what this court interpreted in multiple judgments, my lord, is
No,
that,
if there is a dispute, they will settle the
my
dispute.
lord, minus the dispute, the interpretation of the guidelines by this honorable
But who
court-
are you to question it?
My lord, I'll just place,
If it was dispute, if it was cancelled by Mr. Borthakur and it is put to challenge by them, then this matter would have been looked
my
into.
lord,
But
very-
not by an unsuccessful,
my lord,
who is in group 3.
desperate, my lord, so many representations and complaints, official complaints by way of payment of fee. I have placed it before the HPCL. and
Payment
they
of fee
didn't take-
regarding,
If you have to file a complaint, I have to pay a fee of 5,000. So I did that multiple times. and-
see, the dispute may arise. If it may arise if the HPCL takes a decision not to give it to him, he may come up with the code, then we can adjudicate.
My lord.
But will you do it at your instance?
My lord, then they have to go for an evaluation based on these particular documents. They have not answered it, my lord. The HPCL has simply relied on this particular document and proceeded.
Mr. Bharadwaj, you are in the group 3.
Right.
Your rights are very, very limited.
My lord. But still, my lord, just the interpretation of the guidelines, my lord. Let me just place this.
We're too technical.
Well, let me just place this.
If we have interfered in this matters, but not for group 3, though both were at par. Draw of lots, the other one had, but there were problem with the land documents. It was raised. Now first, not discrepancy, your weakness is that you're in the group 3. Nonetheless, you put a question. That question has to be based on clear materials, not on speculation.
No. This is not
That
speculation.
tomorrow demarcation is not done, if somebody raises an issue, they'll decide, they'll suffer.
Well, at the very behest, my lord, they went for violation of the guidelines, my lord.
What is the violation?
Well, it said that the consent letter or that has to be obtained from the co-sharers. if they-
Where is the co-sharer? It's been, the part has been muted, only demarcation part is there.
Well,
And
but-
now subsequently demarcation is also done.
Till this court held that even the moment demarcation is not done, everyone is held to be a co-sharer. And even if there are multiple tags under the same.
Those are principles of law in appropriate case where the dispute is regarding the land between co-sharers or not of
No,
a matter of this
here-
nature.
The judgments which I want to place before your lordship, their candidature was rejected by by the oil market.
Let us see.
company. But
Which one? Please give the citation.
my lord, the first one is 2025 SCC online,
2025
SCC online,
online Gauhati.
Gauhati 3003. 3.
Ramchandra Sarkar.
Yes, ma'am. Para 2, madam.
There are 2.
Yes. The petitioner is aggrieved with the impugned letter dated 10/1/25 issued by the respondent number 2, by which the petitioner's application for awarding RO dealership within 1 kilometer of Ajmal Senior Secondary School, Senga, on LH towards Haju on Borpeta Haju Road, district under SC category, advertised on 28/6/23, has been rejected on the ground. There's the same advertisement, madam. On the ground that the petitioner's lease deed had not been executed by all the 6 co-partners of the land in question. It had only been executed by 2 co-partners instead of 6. Now, the petitioner's counsel submits that the petitioner had been provisionally selected for award of retail outlet dealership by way of draw of lots by letter dated 13/12/2023. However, after verification of the documents, the state respondents rejected the petitioner's application on the ground that the petitioner's lease deed did not conform to clause 4(6)(a), the same clause now. Because only the lease deed was executed with 2 co-partners and not 6. And the decision, my lord, at para 10, Perusal of the lease deed dated so and so with regard to the above clause shows that the same had been executed between the petitioner, Ripon Ali and Sahidul Islam. There is no signature of the other four co-patadas in the lease deed dated 16/10/23. As such, there is nothing to show that all the co-patadas had given their consent to the lease of the said property to the petitioner. The same not being in consonance with clause 4(6)(a) of the guidelines on selection of dealers for regular and rural retail outlets, which is an essential condition of the tender. This court does not find any infirmity with the rejection of the petitioner's application. Further, the co-patadas of the said plot and the petitioner are not related in the manner provided in 4(6)h. As such, 4(6)g is not applicable. But the rejection was that was upheld.
Now, after a validly executed sale deed, will the concept of co-patada remain?
Yes, madam, that is what. madam,
No, in,
what we
in,
need
in
to-
legal sense.
Yes,
You may be having a common patta. Will you have a right on the person which has been sold out by registered sale deed?
because.
Is there a requirement to have a NOC?
Because the demarcation exercise has
No,
not
no.
taken place.
That will be too technical. You have to give some leverage to the owners to execute their works. How can you put a fetter like this? You are a competitor, not even in group 1. You are in group 3.
My lord, provided he is.
You cannot put a fetter. Some leeway has to be given, provided we find that other materials are prima facie in order. If yes, the sale deed was executed later on, but the last date you had
No, that's the
specified
date,
as
sir.
17/10/2023. We have seen that the sale deed is of 3/4/21, mutation done, yes, demarcation not done, but will it be a factor so measured that they can refuse the candidature? That is the question you are asking.
Fine.
This decision perhaps will not cover your case. This is a clear case where co-pattadas did not have the sale. There is a requirement. Any other case, Praveen Das?
Other two are also exactly on the same ground, ma'am. Exactly on the same.
What is Praveen Das?
But here also, Probin Das.
WPC 4369.
Yes, ma'am. There also it was rejected because NOC was not there. And again, the court held as para 10, my lord. If the offered plot is on long-term lease and there are multiple owners, then the lease deed should be executed by all co-owners of the offered plot. Further stipulates that in case the lease deed is not executed by all the co-owners, such lease deed shall be treated to be invalid. On the case on hand, as noticed here above, the co-pattadas had not appended their signatures to the lease deed, nor granted their no objection to such execution of lease deed by the two of the co-pattadas. So since clause 4(6)(a) was.
See, that registered sale deed is also not the subject matter of any challenge.
No,
If you have got that some litigation is pending, questioning the authority of the father
yes,
to sell a portion of the land to the two sons, Pranab and Kanak,
yes,
matter would have been different.
Yeah.
A cloud is still there on the distinct rights of the lesser in favor of Mr. Ahmed. Now, the rights of the lesser is not been put to question. You're only trying to question which part of the land of the greater area is the part which has been leased out.
Yes.
That is the
yes.
Next.
The last
2024.
one,
Nipun Das.
Nipun Das, my lord. Same situation, my lord. There were two owners. One executed the lease deed. And again, it was rejected and the rejection was upheld.
See, your argument is on a more finer point. This will not help you. These are exactly on the aspect of co-owners. Here is not a co-owner. Ownership has changed hands
Right.
to the lesser. Now, the area you say is not very clearly demarcated, so you do not know. That is up to the IOC.
Well, if a direction is given to them, at least to explore. Let
That
them,
is for the IOC.
let them examine the issue, since they have not. If they can
Mother.
show from the
Right.
records that they have examined that particular issue.
Not in all cases, Mr. Bharadwaj. Extraordinary jurisdiction, something has to be made out. And some leeway, some leverage has to be given. To act legally, of course, cannot go within, outside the bounds of law. Yes, 2 minutes, it's anything you'd like to say.
The land has
Only, but we have made up our mind, but only
Yes, ma'am.
anything else?
No right has been arranged as yet, madam.
Hmm?
No right has been arranged as yet, madam.
No, right for fair consideration is always there.
So,
No,
land is
right
like-
for selection may not be there, right for fair consideration. And right to see that transparency has been maintained is also already there of an aspiring candidate.
So,
That you
land is
cannot
like-
deny.
I cannot, beyond the records,
Yes.
the opinion is a specific matter,
Hmm.
whether a specific land matter which is leased out.
But tell us, how would you determine which part of the broader area of land belongs to the lesser of Mr. Ahmed, which has been leased out to him?
Our letter may 146, this, the patta has been made, madam. The specific patta has been made, madam.
Oh, now demarcation has been subsequently made.
146,
Page, date,
12/11/25, madam.
12/11/25.
Yes. New patta has been issued, madam. New tag in the patta. Madam. Page 146.
Matter gets sealed then, okay. And what is the present stage?
So LOA has been issued.
When? Was there any interim order? No.
No.
LOA has been issued on 30/7/2025, madam.
3730
Yes, madam. And NOC,
in favor of R6.
yes, madam. And we have obtained the NOC from the district commissioner. So we are in the process of issuing the LOA, madam. And to commission the,
Letter of interest has been, letter of intent.
intent has been issued on 30/7/20.
Now you'll be issuing what?
The commission, madam.
Have you constructed? You'll do construction after what clearance? What further letter will you issue?
The OC is required, the NOC has,
NOC has been given by
Yes.
district commissioner.
LOA, my lord, letter of allotment. There-
Allotment.
Allotment. Thereafter, the petroleum products will be coming.
now petrol license is required, madam. Petroleum explosive license is required.
What license? Petroleum license.
Petroleum and explosive license.
Explosive license.
It is in the
That is
process-
not a precondition for
No,
bidding.
no, no.
After you are successful, then you take the license. Suppose a party fails to or is denied the license for valid reasons, then what do you do?
But we can't, madam, because again, madam, we have to read off, madam, if it is cancelled, madam. Then the system can-
Why don't you have this as a, is it a very expensive procedure to have an
So,
explosive
we
license?
require a certain amount of money, madam.
Okay. Yes, Mr. Ahmed, anything? We have not rightly pointed, we have rightly pointed out that your lawyer is the panel advocate of IOC. That is wholly improper.
Yes, that is very.
Where page? 180. Oh, 180, 731. One eight zero is your seal deed.
Next one.
180 schedule. Okay. Please write. The selection of the respondent number 6 for allotment of a rural retail outlet dealership of HPCL, in which the petitioner had also participated pursuant to an advertisement dated 28/6/2023, is the subject matter of challenge in this writ petition instituted under Article 226 of the Constitution of India. Full stop, para. Thereafter details, comma, it is contended that pursuant to an advertisement dated 28/6/2023 issued by the HPCL for such allotment, comma, the petitioner, along with others, including the respondent number 6, had participated so far as location under serial number 266 is concerned, namely page 22 for daily, 226 to location. Full stop. The conditions mentioned in the advertisement had three groups qua the possession qua the ownership possession of land. And since the petitioner did not have any land, he was placed in group 3. On the other hand, comma, the respondent number 6 was placed in group 1 as he had offered land by means of a registered lease deed. Full stop. The challenge is with regard to the aforesaid lease deed, which has been offered by the respondent number 6, with the prime contention that though the lease deed was executed, comma, there was no clear demarcation and there were other co-pattadas. Full stop. I have heard Sri P. Bharadwaj, learned counsel for the petitioner. I have also heard Sri S. Bhattakur, learned counsel for the HPCL, and Sri I. Ahmed, learned counsel for the respondent number 6. Full stop. Para. Sri Bharadwaj, the learned counsel for the petitioner, has drawn the attention of this court to the description, to the prescription of land as mentioned in clause 4 within bracket 6 of the advertisement. Full stop. Since the controversy is with regard to the land offered by the respondent number 6, who claims to be in group 1, comma, the learned counsel has submitted that under such to be eligible to be placed under such group 1, comma, applicants is required to have suitable piece of land in the advertised location, either by way of an ownership oblique long-term lease for a minimum period of 19 years, 11 months. Full stop. He has also drawn the attention of the other conditions, including at serial number A, which prescribes that the land should be available with the applicant as on the date of the application. And in case of multiple owners, comma, all such owners should execute the deed or submit NOC. Full stop. He has also drawn the attention of this court to clause G, small g, which states that if the land is owned by different, by family members, comma, each family member is required to give an NOC in case the applicant is one of such family members. Full stop. He has also referred to note 3 of the said condition. Full stop. The learned counsel has submitted that a lease deed was executed in favor of the respondent number 6 on, what is the date of the lease?
This is 25th of July, 23, my lord.
On 25/7/2023, which was offered by the respondent number 6. Full stop. He has, however, submitted that though the lessor had purchased the land via a registered sale deed on 3/4/2021, comma, the demarcation was not done prior to the last date of submission of the bids, which was 17/10/2023. Full stop. He has submitted that in absence of demarcation, comma, the land offered by the respondent number 6 cannot be identified, and therefore the selection of the respondent number 6 by placing him in group 1 is unreasonable and arbitrary. Full stop. In support of his submissions, comma, the learned counsel has relied upon the following decisions. Decisions carried didiba, tasot moi eta eta heri kori dim. Next. The learned counsel for the petitioner accordingly submits that the entire process being not in accordance with law requires an interference, and the land offered by the respondent number 6 cannot be accepted by holding that the land offered by the respondent 6 cannot be accepted, and he be placed in the category 3 and a fresh selection be made. Full stop. Para. Per contra, comma, Sri Bothakur, the learned counsel for the HPCL, has submitted that no rights whatsoever have accrued upon the petitioner to institute the present challenge. Full stop. He has submitted that admittedly the petitioner did not qualify himself to be in group 1 and was placed in group 3. Full stop. On the other hand, comma, the respondent number 6 was found suitable to be placed in group 1 and the subsequent actions were taken. Full stop. He has submitted that all actions taken were by following the due process of law and bona fide. Full stop. He has submitted that the sale deed in favor of the lesser of the respondent number 6 is dated 3/4/2021, and there is no dispute in this regard. Full stop. He has also submitted that the lease deed by both the owners of the land in question, who are the lessors, had executed the lease deed on 25/7/2023, which is before the last date of submission in terms of the advertisement. Full stop. As mentioned above, comma, the last date of submission was 17/10/2023. Full stop. He has submitted that subsequently the demarcation was also made on 12/11/2025, and new patta and DAG numbers have been issued in favor of the lessors of the respond number 6, full stop. Subsequent thereto, comma, no, subsequent thereto, no, comma. In the meantime, comma, the letter of intent was issued on 30/7/2025 after the NOC was issued from the district, by the district commissioner, full stop. It is now the stage for issuance of letter of acceptance, letter of allotment, full stop. Para. No, para. No. The learned counsel for the SPCL submits that the writ petition be dismissed and the allotment procedure be dismissed, para. Supporting the submissions made by Sri Borthakur, comma, Sri I. Ahmed, learned counsel for the respondent number 6, has submitted that the present challenge is without any substance, full stop. He has also submitted that the sale deed in favor of the lessors dated 3/4/2021 clearly mentions a schedule of the land by which the land is clearly identifiable, full stop. Para. The rival submissions advanced in the bar have been duly considered and the materials placed before this court have been carefully examined, full stop. Para. It is not in dispute that pursuant to the advertisement dated 28/6/2023 for allotment, comma, the petitioner and the respondent number 6, along with others, had participated, full stop. It is also not in dispute that the petitioner was placed in group 3, full stop. The dispute, however, is placing of the respondent number 6 in group 1, which requires the applicant to possess own land, either by own land, which can also be by means of a long-term lease, full stop. In the instant case, comma, it is not in dispute that the registered lease deed in favor of the respondent number 6 was executed on 25/7/2023, which is before the last date of submission, that is 17/10/2023, full stop. The challenge is, however, on the aspect that though such lease deed was executed, comma, there was no demarcation of the land which originally belongs to a larger plot owned by the family members, full stop. As per the case projected, comma, the demarcation was done after the last date of submission and the same would be hit by the clauses of the tender, full stop. Para. From a careful perusal of the materials on record and as admitted by the learned counsel for the respondents, comma, the demarcation was indeed made on 12/11/2025, which is after the last date of the submission, full stop. However, the question will arise as to whether lack of demarcation before the last date can be an issue which can be raised by the petitioner, who is not only a competitor but was placed in group 3 of the selection process, full stop. It is not in dispute that the sale deed in favor of the lesser of the respondent number 6 is of prior date, full stop. For the sake of clarity, comma, clarity, comma, it is seen that the sale deed is dated 3/4/2021 and the lease deed is also dated 25/7/2023, and both were of prior point of time, full stop. What is also to be noted is that there is no challenge regarding the ownership of the lesser of the respondent number 6, as the sale deed dated 3/4/2021 is not the subject matter of dispute in any forum. Full stop. Para. The challenge is on the aspect of lack of demarcation. Full stop. This court is, however, of the opinion that when the IOCL, HPCL authorities are satisfied on the papers, on the list deed, registered list deed, furnished by the respondent number 6, comma, the issue which has been sought to be raised by the respondent by the petitioner would amount to putting a fetter on the decision-making process, full stop. After all, it is right that the owners, that certain free play is required to be, certain free play in the joint is required to be given to the owners while making a decision, full stop. Such free play, however, is to be within the bounds of law, and in the considered opinion of this court, comma, the decision taken by the HPCL authorities cannot be said to be arbitrary or unreasonable. Full stop. It is further not the case that a mandatory condition of the tender has been violated in the decision-making process. Full stop. Para. As far as the decisions, case laws relied upon by the petitioners, comma, this court has noticed that the facts and circumstances of those cases are wholly different from the case in the present, from the facts of the present case, full stop. In the case laws, comma, the ownership of the petitioners which were questioned by the authorities and their candidature rejected were upheld by this court as such ownership was found to be clouded, full stop. Para. Under the in the conspectus of the aforesaid discussion, comma, this court is of the opinion that no case for interference on merits is made out, and accordingly the writ petition stands dismissed.
Obliged.
Lordship, in respect of item number 4, Lordship, item F, when the matter was called, Lordship may record the presence of S. Dotton.
If you are not there, how do you record?
I wasn't on legs in the,
Huh?
I was on legs in another court, Lordship.
We do not know. If you are not there, how can you? This will be amounting to fraud. Petitioner not present, yet names recorded. We are not do. Will not do.
No.
Item 6.
May I please, Your Lordship?
Yes.
My lord, kindly see order dated 27/4/26, my lord.
What is this matter?
Matter says that over the patta land of the petitioner, they are, the AGCL is proposing to propose to transmission line through the land of the petitioner, my lord.
আগত নাম এপিএস শুনে নেলিখিবা নাম নেলিখিবা কিন্তু নাম এপিএস তো লিখিম অলপ বদলাই দিম
Yes. What is it?
Propose to transmission line through the land of the petitioner without acquiring land or without,
Affidavits filed, Mr. Gogol.
my lord,
So we can take it up for disposal.
Yes, man, because the time bound project is to end by 26.
Oh, yes. What is it?
my lord,
Let us finish this off. Let us finish this off. What are your facts?
kindly see, my lord, order dated 27/4/26, my lord.
27/4.
Yes. In this petition. From paragraph 4.
Yes.
The case of the petitioner herein is that petitioner is the owner of various plot of land which are covered by so and so. The respondent number 2 and the respondent number 6 has proposed to lay down a transmission line of so and so over the petitioner's land covered by patta number so and so. The petitioner has submitted representation to the respondent authority not to do, taking into account that petitioner's land would become useless. This.
Yes. Yes. Yes.
The same having not been considered, petitioner approached this court by filing writ petition number so and
We
so.
remember these
Yes.
two families whom you
families.
said that you will relocate them.
Yes,
That
we
is
have-
your case.
Yes, now kindly see, my lord, at impugned order,
Hmm.
on the basis of that impugned order,
We had passed certain orders thereafter. We
page
had,
27,
yes.
page 26 is the impugned order, my lord. And page property part, kindly see page 27.
So he's not aware. You had taken instructions regarding the sketch map. What is it?
My lords, and instructions are compiled really constant. The people are good expected in law under some languages.
No, doesn't matter.
The sum and substance of the instructions is this, that is the best technical feasible route, my lords. And he is entitled for compensation. That is my instruction. Because we have conducted two surveys which we have been.
See, there, we need to give them that much of leverage, which should be the best feasible route.
My lord,
And there are
lord,
number of case laws
what,
that cannot be restrained.
kindly one paragraph I am showing, my lord, page 27 kindly.
27.
Yes. Last part, my lord. This is order passed by the AGCL, my lord.
27.
Yes.
Order dated.
It is page 26, order dated 2026.
AEGCL.
AGCL.
Okay.
Kindly see page 27.
It won't go down, Sandan. Sandan. Won't go down. Okay. On, no, opposite. এখন অন করে দিব দিবা তবে কৈ দিব দি দিও ফোনখন দি দিও বেছি গৰম হয়
Page 27.
Yes.
Whereas after careful perusal of document, technical report, several survey report submitted by the concerned official by AGCL and hearing of Avinash Das, it is inter alia observed.
You are Avinash Das.
Yes. Observed that the above all the facts on record finding on the joint inspection technical opinion show that the existing approved alignment of the aforesaid transmission line has been finalized after due technical evaluation and is designed to avoid existing residential house to maximum extent possible. Hence, the undersigned is of opinion that the existing approved route is the best feasible route and rerouting of the line from existing approved route is not feasible. However, if Sri Avinash Das can arrange a technically feasible separate route for the span from location number 3 to location number 4 with the approval of district administration within 90 days, then the existing route from the location number 3 to location number 4 may be shifted to the new approved route. Moreover, Avinash Das shall have to arrange the relocation of dwellers, if any, come along the proposed route at his own cost in consultation with the district administration.
Yes.
Now, after passing of this order, the district administration, my lord, one route has been surveyed, my lord, at the instance of AGCL. That I have given at page 4, my lord, page 21, annexure 4. And this, lordship got it.
Yes.
This is the, on 21/3/2026, it has been done, carried out. And this document has also been handed over to me also, to the petitioner also.
What is this? Please explain it to us.
In upper part is the, now they are proposing to, from location number 3 to location number 4.
Yes.
But earlier they are proposing that, which they are proposing in the below line. Below line. This, there is no mention of 3 and 4. These two pole is over my land, my lord. And now, when this 3, from 3 to 4, if it is relocated, then two affected family will be, there will be two affected family And this land entirely a government land. Entirely a government land. So I have already taken on the basis of instruction of the Deputy Commissioner, my lord, these two family I have already shifted to my own patta land by giving the construction area by house also. Now there is no embargo in taking this route, my lord.
What about the technical feasibility, the cost part?
Cost part will be, my lord, it will be lesser, cartel.
Why you're taking
Because
a,
why it will be
taking a
cartel?
longer route?
My lord,
You're
why
taking
it,
a longer route.
no, it will be shorter route and as well as the land cost. They will not have to pay the land cost also. Requisition cost also they will not be required to pay.
No, we are asking on the feasibility part. The routes needs to be the shortest.
Shortest, yes.
Now it will be a longer route.
No, it
will
is
come.
shortest, my lord. Upper part.
Upper
from-
part would be the shortest. That is what they are
Yes.
proposing.
No, they are proposing longer part,
Which one?
below one.
But you said 3 and 4 are.
Yes, 3 and 4 now, after re-survey.
You are proposing 3 and 4.
Not I am also.
Mane, you are also suggesting
My suggestion as well as with the district administration.
3 and 4.
3 and 4.
Yeah, that appears to be a shorter part.
Shorter part.
Here the question is not short or long or wide. Here the question is technical feasibility. My lord, there are certain technical issues. My lord.
And anything else, Mr. Ghosh?
My lord,
Let him finish, then we'll come to
and
you.
apart from that, my patta land, they are proposing to taking away my patta land without any requisition or acquisition, my lord. They are simply proposed. Earlier they have,
No, there's a requirement of any requisition or acquisition.
but yes, but
Unless your land is acquired for making some structures or it's only
my
a,
lord, if these two poles are passes through my land, my lord, the entire 5 bighas land will be,
for that you'll be receiving compensation. That's a different matter.
yes.
First, let us consider anything else.
And my lord, the proposed, which has been proposed, my lord, Deputy Commissioner filed an affidavit also. Kindly see the affidavit filed by the Deputy Commissioner.
Page?
Running page, my lord, page 58.
58.
May 58.
58. That is by you.
No, my lord, it is by circle officer.
Now there is some renumberings in the pages. This is by 58 is been affidavit in reply by you. What is the affidavit you are talking about? R5.
R5.
Bolin Baba Balari.
Yes. The
Circle officer.
circle.
This is 62.
The deponent presently serving as a circle officer, Lanka so-and-so, a copy of the writ petition. Kindly see paragraph 4. That with regard to statement made in paragraph 9 of the writ petition, deponent back to states that as per letter received from so-and-so an alternative route.
Page.
Page
Next paragraph.
paragraph 4.
Okay, 63. 63, the same change of pages.
Dag number 98 and 99 of village so-and-so, Lanka Circle was proposed after joint verification by the petitioner and AGCL. Based on this report, a field inquiry was then conducted by Office of the Circle Officer and observed that 2 households will be required to be shifted in case this alignment route is taken.
Alternate route
is taken. If it is found technically feasible by AGCL, the Office of the Circle Officer, Lanka Revenue Circle, does not have any objection if alternate route through Dag number so-and-so is taken. Further, the Office of the Circle Officer, Lanka Revenue Circle, does not have any objection if the petitioner accommodate these 2 families of the petitioner lands, so-and-so, provided the petitioner settle this family through gift deed executed as per law.
Circle officer is in your favor.
Not only circle officer, my lord, another affidavit also filed. My lord, it was on Yes, it was filed on, my lord, 27/2026.
By whom?
By the same circle officer. Annexing the document, my lord. Paragraph 2.
Which document?
The sketch map, my lord, which has been prepared subsequently. Which 63.
Yes, page. Which paragraph? Paragraph 2.
Paragraph 2. The sketch, same sketch map they submitted. Which matter?
Yes.
There,
See, it is not only his convenience or inconvenience. He has also taken some support from the circle officer in by way of two affidavits. One is the principal offense, the other clarificatory in nature, because this letter of 23/3/26 was not enclosed in the earlier affidavit. And he has also enclosed the subsequent sketch map, which shows that the route which the petitioner is would be benefited is a shorter route. And he has also taken steps for the displaced families to relocate them. These are the facts which he says would be relevant for adjudication. Now, what is your stand?
can you come to page number 18 of the lead petition?
1/8.
One. Might have been third paragraph, grounds, technical grounds, my lord, I enumerated, my lord. Why is it not feasible? Because we follow certain rules, my lord. If I may read, my lord.
Yes, please.
Reading the related portion, the officials of AGCL submitted a route which has been proposed, already been proposed by AGCL. It's the best feasible route for constructing the aforementioned transmission line in accordance with the concerned official of the case. Such amount of land, as informed by Sri Abhinav Das, will not become unusable for crops cultivation. The concerned officials of AGCL further submitted a proposal of Abhinav Das. Another route was examined and resurvey also conducted. Number AP3 and AP04 of the proposed 220 kV Sankarjat Nagar Misa transmission line was carried out. However, the same could not be found feasible for the following reasons. And now these are technical. The number one, the angle of deviation of the AP2 after rerouting is 107°24 to 1273 latitude, which is more than 60°, hence not feasible. 2, the route also passes over residential houses over between AP2 and AP3. 3, also the route passes over the boundary of the Government Office, Department of Handloom and Textile between AP2 and AP3. Also, the route passes through the boundary of public park in AP3 and AP4. Number 5, the angle of deviation of AP5 after rerouting is 76°20. These are the geographical longitude latitude, which is more 60°, hence not feasible. So, the question is not short or long. Once we the connection or the joint is bended to up to degree, it causes us inconvenience. That line suffers. That carrying capacity of line suffers if it is bended. And I will kindly come to page 19.
19.
19. Here, two sets of observations, The angle of deviation for AP1 is it has become 88°, whereas technically it should be 60. For the proposal which is beyond the highest angle limit of 60°, let's say finds that,
Observations?
Yes, observations, option 1.
Yes.
And I will find that it becomes 80°, but technically it should be only 60°. Once we reroute the line, it becomes 88°. And the civil foundation of AP1 is already completed with 5° angle. the route passes over boundary of existing government office so and so well. Again, lordship at page 0.3, lordship will find the angle of deviation is 68, which is above the maximum limit of 60°. Also for spotting a highest angle DD type tower. Highly technical one. Also, the route passes over the existing houses in between the AP3 and AP5, which is also allowable as per standards of transmission line for safety, like public safety violation. Number 5, the angle of deviation of AP5 is 95°, which is above the maximum angle limit of 60° for spotting a highest angle DD type tower. Considering the above, the proposed route is not feasible for construction. The approved route, which avoids existing house, is best suited. It's not my long or short. Once we bend the joint beyond this permissible limit, my lords, the carrying capacity of that line suffers. Again, my observation 2, the line passes over existing house so and so, it's public as per standards of transmission line for public safety violation. And there's another order, my lords, at page 26. It's repeated, but I'm harping on this because we will lots of again find this.
No, what about the last part of this page 19? Your managing director.
Page 19.
19. Sri Avinash Das submitted second last paragraph. Sri Avinash,
That was also done again.
proposed route is diverted. Please read this.
Considering the
No, thereafter, after observations, this option 2.
just submitted that if the proposed route is diverted the line land adjusted to his own land, then the affected families for such diversion will provide land from his own land. So he requested to shift the route so that his land can be exempted from erection of tower and construction of transmission line. That is his step.
Thereafter, considering.
Understanding is of the opinion as per proposal of that the feasibility of shifting the proposed route may be explored. Accordingly, AGM 222 or 220 KV Samaguri GSS HCL is directed to examine the route proposed by Sri Avinash Das will be feasible for to shift the existing proposed route from all aspects and submit a detailed report. This is of date 2312, signed 2312. And then, my lord, after that, we come to, my lord, page 26. Joint survey was done. Page 26. The office order, my lord. Shall I read, my lord?
Yes, please.
Whereas in pursuance to the Honorable Gauhati High Court order that is so and so, the notice that is so and so for hearing was served upon Sri Avinash Das late of so and so.
This was an earlier order. Or what?
My lord,
Earlier repetition was there.
Then, my lord, whereas for different N, whereas for different joint field survey was conducted on 3/7/25, 6/12/25, 27/12/25, and 14/2/26. Along with the landowners, Mr. Avinash Das, were exploring a feasibility for rerouting of AP3 and AP4 of 220 kV DC line from Shankardev Nagar to Misa, and several hearings of Mr. Avinash Das were held and found that proposed routes were not technically not feasible due to the following reasons. Reasons are spelled out, my lord. Number 1, for rerouting the transmission lines along the proposed option shown by Sri Avinash Das, residential house will be falling under such proposed route and same will be violative of regulation 63 of Central Electricity Authority. Bracket measures relating to safety and electric supply, regulations 2023. The transmission line route survey inherently involves avoiding houses, structures, and densely populated areas by incorporating this as primary criterion in the route selection. The best route is selected and approved considering all technical feasibility, design requirements, minimum social and environmental impact. Accordingly, the best route has been carried out and a detailed survey, design, and conductor profile is approved. It is also noted that the 220 kV DC line from Shankardev Nagar to Misa is for public interest at large, and delay in the project completion would lead to huge financial loss to public exchequer. Hence, in the interest of public at large, it is very essential.
No, what we have read this, but what is concerning us is that after all this exercise, pursuant to orders of this court passed in 6459 of 2025, at page 27, you still give an option to him. Page 27. Secondly, however, if so-and-so can arrange a technically feasible separate route, what is the meaning of this?
This, I have to submit what kind of language is, maybe he's.
No, he's your managing director,
Yes, MD,
not even a district administrator.
This language doesn't suit him, my lord, that I have to give it. Otherwise,
No, no, after all this exercise pursuant to directions of this court, if you still say that Avinash Das can arrange a technically feasible separate route for the span of location so-and-so to so-and-so with the approval of the district administration. And he has done so, circle officer by two affidavits support him.
yes. But my lords, if isolating this para, my lord, if you isolate this para, otherwise this, the public interest has been spelled out, technical feasibility has been spelled out by the arguments, my lords. Also, my lord, these paragraph needs to be, my lords,
No, this is not the version of the district administration. We would have taken note if a separate, they are not technically
Yeah.
in the same level as you are
Right.
to make the decision. They can only facilitate you to arrive at a decision. Now, this is by your own managing director.
Right.
You give a separate route, take the approval of the district administration. What is the meaning of this? You could have stuck to your decision that this is not feasible. You have done the exercise. You cannot.
Exactly, my lord, exactly.
You still leave a room, you still leave a window open.
My lord.
Now he's trying to explore and district administration appears to support him.
My lords,
And this is 20 to 2026.
my lord. That paragraph would not have been inducted there, my lords. He might have held something, but technical feasible, even direct, my lord, in the capacity of MD, he is also has to be fed by his ground staff.
Now, after the sentence not feasible, the communication should have stopped. In paragraph 27, the concluding portion. And whereas then 7 lines thereafter, the existing approved use is not feasible. Then you do not stop there. However, you start again. However, have you found it?
Man, however, if Shri Avinash Das.
Last,
Yes.
can arrange a technically feasible separate route for the span. First, he is a layman citizen. How can he arrange number one? You say that. Then you say that he takes the approval of the district administration, which he somehow takes it. Administration is also in his support. He takes steps to relocate the two families pursuant to orders of this court.
He should have stopped at that, he should have added that however and then that
Then
subsequent.
what about the order of this court pursuant to which he had taken steps to rehabilitate two families? That, of course, will not give him any right for this, but will definitely have some impact on the decision making because it's pursuant to orders of this court.
I will answer, man. But I was just, on last occasion, I was going by the specific relief act. My lord, apart from that, I found out another judgment, my lord, is Kushala Sethi. Though it's about roads, my lord. But it says, my lord, when it technically a road was, my lord, surveyed, the petitioner came before the court that no, you realigned everything. Para 24 there, my lord.
Paragraph
24.
24.
24. So is it in the context of roads, my lord? Shall I read?
Just a minute, please.
Lords, we'll find
This
it.
is reported 2011
Yes, man, it's reported.
12 SCC
11 SCC.
2020
12 SCC 69.
2011 12 SCC
69.
69 Union of India versus Kushala
Kushala City.
Shetty. Paragraph 12. 24.
24.
Please read.
Here, it will be apposite to mention that NHAI is a professionally managed statutory body having expertise in the field of the development and maintenance of national highways. The project involving construction of new highways and widening and development of the existing highways, which are vital for development of infrastructure in the country, are entrusted to experts in the field of highways. It comprises a person having vast knowledge and expertise in the field of highway development and maintenance. NHAI prepares and implements projects related to development and maintenance of national highways after thorough study by experts in different fields. detailed project reports are prepared, keeping in view the relative factors, including intensity of heavy vehicular traffic and larger public interest. The courts are not at all equipped to decide upon the viability and feasibility of a particular project and whether the particular alignment subserve the larger public interest. In such matters, the scope of judicial review is very limited. The court can nullify the acquisition of land in the rarest of rare cases. The particular project, if it is found to be expressly contrary to the mandate of law or tainted due to malafide. In the case in hand, neither any violation of mandate 1656 Act has been established, nor this charge of malice in fact has been.
So there, Mr. Gogoi, there is no dispute to this proposal. Expert body's recommendation, we do not have the expertise, but your own expert body's observations, that is what is causing the problem. Now, what do you finally say?
I finally say, Madam petitioner, with due respect, is trying to dictate matters at the rerouting matters, which is technically on ground staff. On ground level, it's not possible. Madam. He is entitled for compensation. That is admitted, Madam. In fact, we have rules covering that. Madam, there's a even there's a rules are there, Madam. Notified is 2024.
Yes, state, Mr. Thatia.
It is matter key. It is found technically feasible matter. Then it can be done. Okay. In pair provisions. If it is found technically feasible by the AECL, the office of the circle officer does not have any objection. That is how.
My lord, one thing, my lord, though I am not on technicalities, my lord, but I will show the diagram.
No, that we have seen.
Yes, that
See, that part we may not have the technical expertise.
technical expert, yes.
Expertise.
But in the I would, my lord, kindly see the, again, my lord,
Diagram.
page 21.
No, Mr. Ghosh,
No.
we have seen the diagram. On
on-
prior FSI, it seems that you are on a shorter route, but
Oh, no,
the
not the
grounds-
shorter, only the ground which has been said that 90-degree angle will be less than 90-degree. Kindly see the angle, not a single angle is 90
Angle-
degree.
That is not that angle.
angle is not feasible from a diagram.
He is-
Angle, it is only the route. Angle will be on the height.
Kindly see the angle,
have seen it.
kindly once see,
Yes.
not a single angle is in the 90
I'm
degree.
not speaking about that angle. This tower.
All are more
50
than 90 degree.
Madam, 50 is
Number
tower.
one. Number two, my lord. Number two, this report, this page 19, which has been read out, my lord, that after that, there was again rerouting, my lord. This is the subsequent, my lord, one. Third time this rerouting has been done, my lord, this annexure 4. It's third time, my lord.
This rerouting is done by whom?
By the AGCL as well as by the district administration.
Mr.
AGCL was
No,
party.
there
I
are-
have made a categorical statement in my writ petition. In presence of AGCL, it has been done. Kindly see, my lord. Because in the order of the,
Instructions are clear, my lord. After that one page instruction I placed, my lord, when the matter started, we denied any input, my lord.
why this has been done, my lord, after passing of the order in February, my lord.
It is-
But there was no joint survey.
No, don't, sir.
Paragraph 10 of my writ petition, my lord.
That we have seen, but there is no joint survey. Paragraph 10, how is it answered in the affidavit by Mr.
No
Gogoi?
answer, nothing. That your petitioner back to states that thereafter respondent number 6 resurveyed the proposed line in presence of the petitioner along with respondent number 5. 5 is, and accordingly respondent number 6 prepared a sketch map. And after going through the new proposed line, 2 families who were occupying the government land will be affected.
but 10 has been answered.
And their answer in paragraph 10, my lord, paragraph 6 of their affidavit.
Yes.
That with regard to the statement made in paragraph 5, 6, 7, 8, 9, and 10 of the writ petition, the answering respondents herein state that common notice issued by so-and-so on so-and-so to all affected Pattadar under Lanka Circle for hearing grievance proposed to be held on so-and-so regarding 25. Letter 17/6/25. Later, the meeting was convened on 23/7/25 and was minute. So and so thereafter, petitioner has submitted a representation on 17/6/25 before the Honorable so and so and requested to exempt his land from the construction of so and so transmission line, which according to him may be passed through government land adjacent to his proposed land. It is stated that after receiving the petition, joint survey was conducted on 26/25, in which the route are found to be technically not feasible, and accordingly he has continued for construction of the line as per previous right of way or order. It is stated that earlier litigation number so and so petitioner with a prayer for direction to AGCL exempt the land of the petitioner from acquiring the same for the purpose of erecting so and so transmission line. The Honorable Court pleased to dispose of the aforesaid writ petition by so and so, whereby directed the respondent number 2 and respondent number 3 herein to take representation dated so and so submitted by the petitioner before them for board, and thereafter to dispose of the same by way of speaking order after affording the petitioner hearing as expeditiously as possible within a period of 1 month from the date of petitioner. It is humbly stated that compliance of the order dated so and so Hojai, after examining the representation, petition has been disposed of the said representation by order dated 6/1/26. Kindly see the date. With the observation that hence, after careful conclusion, consideration of the pleading, the records placed on file, minutes of the hearing, the finding of the joint so and so, and technical opinion rendered by the competent authority, it is evident that approved alignment of the transmission line has been finalized after due technical evaluation and is designed to avoid existing residential house and permanent structure to the maximum extent possible. The alignment has been found to be most appropriate, technically sound and feasible, so and so, so and so. Nothing said about the joint survey, my lord, because in the order itself, it reflects that alternative route can be. And before passing this, before taking into this alternative route, my lord, they conducted another survey, page 56, my lord. They are saying about this survey, my lord, page 56 in their affidavit. Page 56. This is second time resurvey about this, my lord. Lordship got it?
Yes.
This is the. In upper portion, my lord.
The present
Present one is
no,
not.
the present drawing which you are relying upon,
This is not.
does it contain any signature of the
No signature.
Signature of the.
AEGCL authorities?
My lord, they have this handed over to me, my lord, page 21. They are in right side in ink mark.
Yes.
Nothing signature, my lord. But this same drawing has been submitted by the circle officer also.
No, they now in the
This support.
in the latest communication which
No,
has been
I
given
have
to,
not received any communication.
no, not to you, which as a part of the instructions, there is 7, 8, 20, 26% to our orders passed.
Yes.
It has been stated that there was no joint survey done with the AGCL.
My lord, my clear specific statement, paragraph 10, they have not dealt with.
They have dealt with.
No, they have not said that they have not done. That is why entire paragraph I have read out, my lord.
They have read.
They have not dealt with. Para 6. And they are dealt with only with respect to the page 56 survey. I'm not with respect to page 56, my lord.
You said is the sketch map and annexure 4
Yes,
was prepared by respondent 6.
yes.
But where is the signature of the respondent 6?
They have handed over to me, my lord, and at the same time, circle officer also submitted along with this affidavit, this document, my lord.
No, a circle officer has he said that this was prepared by the AGCL.
A joint survey has been made.
Where,
Joint
where,
survey.
where?
Paragraph 4. That with regard to the statement made in paragraph 9, Lordship got it.
Just a minute, please.
Read it.
Just a minute. Where are you reading?
Page 60, affidavit filed by the circle officer.
Yes, yes.
Paragraph 4.
60?
61 or 62, I think. My one is page 59.
Paragraph 4.
4.
How does it start?
That with regard to statement made in paragraph 9 of the
Yes.
lead petition,
Yes.
deponent beg to state that as per letter received from the petitioner, an alternative route to so-and-so, the village so-and-so was proposed after a joint verification by the petitioner and AEGCL. Lordship got it?
Oh.
Based on this report, a field enquiry was then conducted, office of the circle officer, and observed that 2 households will be required to be shifted in case of alternative route is taken. It is found technically feasible by AGCL. The office of the circle officer, Lanka Revenue Circle, does not have any objection if alternative route is so and so.
Let us see the complete letter.
This enclosed copy enclosed is in subsequent affidavit they have. Because they have mentioned copy enclosed, but subsequent affidavit, this document has been enclosed.
See, there will be two things appearing, okay? In paragraph 10, you have said that after the order of 27/12/2025, a joint survey was made along with the AGM.
AGCL.
No, AGM of the AGCL.
Yeah.
S1 number 6.
Yeah.
SN General Manager.
General.
Now this, you said that there is no particular denial or specific denial of this thing. And the circle officer has also supported your claim. Now circle officer in his first affidavit indicates regarding such fact which came to the knowledge by way of a letter. Letter is written by you.
Yes,
Letter is not written by EGCL.
Yes.
Now your letter has been enclosed in the subsequent affidavit.
yes.
Letter dated 23rd of March 2026. Now let us have a look at this letter at 68, the second affidavit.
With reference to
So that I'd like to submit that I
Right.
had earlier prayed so and so. In terms of minutes of meeting, observe the undersigned and proposed rehabilitation framework during the field visit with the officials of the EGCL. That is his assertion. Now, Mr. Gogoi, not only in one place.
No, I'll clarify.
No, your stand that it is not technically feasible, that's a different one. We are not saying that we will not consider, we'll consider. But your conduct in having a re-verification, a re-survey by your officer, that appears to be correct. In your instruction, which I have placed before this court today, does not appear to be in terms of the stand of the official respondents as well. A petitioner, of course, it's a word of mouth of the petitioner that we can,
Clarify.
yes.
There are two incidents, my lord. Petitioner is my lord, will kindly come to page 26. Pursuant to court order, there was a joint survey. We are not saying that we have not done joint survey. We have done in compliance of court's order, page 26, it reflects, my lord, there is a joint survey. On different dates, my lord. Dates, my lords, will find in page 26. Joint survey, 3/7/25, 6/12/25, 27/12.
Then what happened?
Then we found it's technically unfeasible. We stopped there, my lords. Thereafter we stopped.
Oh, you are not denying the joint survey.
my lords.
You are having a
That-
joint.
Different, and this is different. This petition harping about this is something different. To find out technically feasible, it's technically feasible or the command of the and with due, my lord, obedience to the court's order, my lords, we conducted a joint survey. But the fresh development which is brought on record by the petitioner, my lords, that we are denying. Even in fact, my lord, that map which he has, the circle officer has brought on record, matches the exact, which is it is annexed by the petition and the petition himself at page 21.
Yes, we have seen that.
Yes, my lords. So these we are denying, my lords. We are never part of it. Because if something should have been happened, my lord, because it's our project which is suffering, we could have exactly produced the minutes. Even the circle officer doesn't produce any minutes.
The circle officer is basing his statements on the strength of a letter written by the petitioner.
Exactly.
Origin is authored by the petitioner. But it doesn't seem that he has manufactured it because he has been consistent in his stand. And earlier also he said that after the orders of this court, joint survey was done. You are also not denying that joint survey was not done. It was in fact done. But the preparation of the map is not by you.
No, no. This is something different because we have our map in. Our joint survey also will see at page 56 of affidavit. It bears our signature.
Great night.
So that map, my lord, which is being denied upon by the petitioner at now at this station, that we don't have any. We deny, my lord, boldly deny our involvement at any point.
Okay.
দাঁড়িয়ে গেল, উপায় নেই আর, কি করি? না, না, আমার লাগবে, ভালো নেই।
What, this map which you are referring to at page 56 is part of what document? There is one letter of rejecting the case of the petitioner on 6.
At page 55, you will see.
What is this?
This is pursuant to the direction by the ADC revenue, and resurvey was done. Again, resurvey by the technical experts. This report is based on this map. It was 6/12/25.
Okay. Page 18 and page 55. 18 is your letter dated 23/12/25.
18 of the petition.
18, yes. It is a letter of 23rd of December 25. We'll find the letter on the last page. At page 23/12/25, we got the date, and now come to page 55. Just before the map which you are relying upon, that
6/12/25.
no, this is not 6/12. This is as directed in the hearing that is 6/12/25. Okay, so this this recording is not of 6/12. It was as per a direction of 6/12. So we do not find the date in this observations. It is followed by this map which you are relying upon. Map also doesn't contain a date. Obviously, map is not required, but we are interested to have the date because when it was done becomes of considerable importance.
Yes, yes.
So this 55 and 18, are they same? Because the observations appear to be the same.
18 is based on 55.
It appears so because you held a meeting on 6/12/25. you go for a joint survey, then you issue this as 2312. Appears to be in chronology.
The contents there on my, there in my, observations also matches the.
You have these observations you have intimated to the parties by way of an office order, isn't it?
Exactly.
Including the petition at serial number 7 at page 20. Page 20, serial number 7. Anything, Mr. Ghosh?
My lord, thereafter, this order has been passed on 20 to 26. Then after that, the subsequent drawing which has been prepared, it was for the third time, my lord. Earlier also I have said this page 56 in the second time. Then on 2026, order has been passed. Page 27 part. Thereafter, again the survey at paragraph 10.
Okay.
That is why the diagram is not matching, my lord. Page 56 and the diagram which I have annexed, my lord.
The poles have already been erected.
Yes, the learned counsel for the.
No, poles have already been erected on your land.
Yeah, no,
Huh?
no, nothing. Rather, the persons
But what have you written in your synopsis, first line?
They propose to erect.
No. Read the synopsis.
Moving. No, not erected, my lord. There is
Read the synopsis.
Yes, there.
You are asking for removal of the poles, post.
No, post has not been.
Then why do you ask for removal?
There is some mistake, my lord. No, it has not been.
What is the relief you are seeking?
Rerouting, my lord.
No, see.
A writ of mandamus shall not be issued directing the respondent authority to take necessary step for
Resettlement of the affected two families.
over the land provided by the petitioner.
You have not structured the petition in the proper manner at all. Synopsis is entirely wrong, even the relief you are praying for.
From the government land and approve the new route of the electricity supply.
You are more interested in resettlement of the two families. That is why we are wondering why this order of 27/4/26 was passed by this court while issuing notice. You made an undertaking that you will take steps to rehabilitate the two families. On those conditions, this work of importance has been put to a halt. The instant petition under Article 226 of the Constitution of India has been filed with the following relief to Court Cordia, page 11. Footstop. Para. as per the facts projected, comma, the petitioner is in possession of a plot of land over which there was a move to lay electricity lines by the AEGCL, full stop. The petitioner had earlier filed WPC 6459 of 2025, which was disposed of on 17/11/2025, directing the respondent numbers 2 and 3 to consider and dispose of the representation of the petitioner filed on 17/6/2025 by a speaking order. Full stop. The hearing was accordingly done, and on 23/12/2025, an order was passed wherein an observation was made that the petitioner could suggest an alternative route with an undertaking that the persons affected would be taken care of by him. Full stop. The petitioner claims to have given such an undertaking, and joint surveys were also done. Full stop. It is submitted that an alternate route was suggested by the petitioner was submitted by the petitioner, which was done after joint survey, and the same has also been taken cognizance of by the district administration. Full stop. However, comma, the authorities, AGCL authorities have not taken any steps for accepting the alternative route submitted by the petitioner, and rather insisting on the original route, which would adversely affect the rights and interests of the petitioner. Full stop. Para. I have heard Sri S.K. Ghosh, learned counsel for the petitioner. I have also heard Sri D. Gogoi, learned counsel, standing counsel, AEGCL. Full stop. Para. Sri Ghosh, the learned counsel for the petitioner, has submitted that after the order dated 23/12/2025, joint surveys were held, which had culminated in the alternate route as projected in a map. Full stop. The petitioner has also reiterated to relocate. No. He has also referred to the office order by the AGCL dated 22/2026, whereafter, wherein an offer was made to the petitioner to have a feasible route along with the district administration and to relocate any dwellers. Full stop. The learned counsel has drawn the attention of this court to the sketch map dated 21/3/2026, wherein the alternate route has been clearly marked. Full stop. He has submitted that the alternate route would be over government land, and the two families which would be effective have already been shifted by the petitioner. Full stop. He has also submitted that no acquisition or requisition proceedings have been initiated before the proposed impugned action. Full stop. Reliance has also been placed on the affidavit in opposition filed by the respondent number 5 bracket circle officer on 17/6/2026, which and the averments made in paragraph 4 are pressed into service. Full stop. The same reads as follows. Averments should read as follows. Into page 63, paragraph 4. The said circle officer has filed an additional affidavit on 27/2026, as the latter dated 23/3/2026 mentioned in the affidavit could not be enclosed, and the said letter has been duly enclosed in the additional affidavit. Full stop. The learned counsel for the petitioner accordingly submits that since the petitioner had discharged his obligation pursuant to the offer made to him, which has also been endorsed by the district administration, due consideration is required to be given by the AEGCL and the matter be settled. Full stop. Par contra, Sri D. Gogoi, the learned standing counsel, has submitted that though, as a matter of fact, after the order dated 23/12/2025, joint surveys were made, the alternate route suggested by the petitioner appears to be an unfeasible one. Full stop. He has drawn the attention of this court to the observations made in the letter dated 23/12/2025 itself, wherein certain grounds have been cited based on technical expertise. Full stop. For easy reference, the grounds are extracted herein below, page 18. Grounds required. The said letter had, however, made an observation that proposal of the petitioner would be reconsidered, pursuant to which, it appears that joint service was done. Full stop. The learned standing counsel has, however, submitted that the present sketch map presented by the petitioner was not approved by the AEGCL. Full stop. Since the matter would have certain significance, this court, wide an order dated 6/8/2026, had directed the learned standing counsel to obtain specific instructions in this regard. Full stop. Sri Gogoi, the learned standing counsel, has obtained written instructions dated 7/8/2026, as per which, no joint survey was conducted with the AEGCL, resulting in the proposed map. Full stop. Para. To dispel any further doubt, this court has looked into the map which has been enclosed to the writ petition. Full stop. It, as mentioned above, the said map also appears to have been endorsed by the circle officer. Full stop. Perusal of the map will, however, reveal that the same is not endorsed by any authorities, not to talk about the AEGCL. Full stop. The endorsement by the circle officer also appears to be on the strength of a letter issued by the petitioner on (23/3/2026). Full stop. Though, as admitted by the learned standing counsel, that joint surveys were indeed made after the order dated 23/12/2025, the specific stand of the AEGCL is that such joint surveys did not culminate in endorsing an alternate plan as claimed by the petitioner, vide the map enclosed in Annexure 4 to the writ petition. Full stop. On the other hand, the learned standing counsel has relied on the map which has been enclosed as Annexure. Where is that annexure?
It's a part of annexure.
Page 56.
Annexure 8. It's part.
Which is a part of Annexure 8 of the affidavit in opposition filed by the
This is filed by the respondent 2.
respondent number 2 on dated 4/6/2026. In paragraph, in page 56, full stop. A perusal of the map at page 56 would show that not only the same is endorsed by the authorities, comma, there is a detailed projection of the houses and other structures in the way, in the proposed route, in the route as well as the alternate route suggested by the petitioner. Full stop. This court, the learned standing council has relied upon a decision of the Honorable Supreme Court reported in 2011, 12 SCC 69, Namdi Diba, wherein the following observations have been made. Full stop. Para. The aforesaid decision is on the aspect of the minimal scope of judicial review in matters pertaining to technical expertise. Full stop. In the instant case, however, in the letter dated 23/12/2025, while rejecting the case of the petitioner, a further window was opened by allowing the petitioner to submit alternate route. Full stop. However, no. In the aforesaid exercise, comma, though joint surveys appears to have been done, comma, the map submitted by the petitioner does not appear to have been done in consultation or approval of the authorities. Full stop. After all, comma, the work in question involves highly technical expertise, and the reasons stated in the letter dated 23/3, not 23, in the letter dated 23/12/2025 appears to be after due deliberation and taking into consideration all the relevant aspects which have been quoted above. Full stop. In view of the aforesaid discussions, comma, this court is of the opinion that the present case would not be one where interference is called for, and accordingly the writ petition is dismissed. Full stop. The interim order passed on 27/4/2026 stands vacated.
Much.
Sri Gogoi, the learned counsel, has also submitted that the petitioner would be entitled to compensation in case of loss suffered by laying of the present transmission lines in terms of the notification dated 4/11/2024. What's the last one, Likhiba? The dismissal of the writ petition will not come in the way for the petitioner to seek appropriate compensation as per the existing notification.
Much. In this writ petition, the respondent side has filed an objection. They have stated that the amount which we required to pay, that has not been paid from the month of April 25. There was some confusion. I have taken the instructions today. The amount has been transferred. It has been paid.
17B amount.
17B amount.
Yes, madam.
I just called up my client, but he has already showed me the deposit slip, but it has not come to his account.
And then he has made a statement, then if you agree upon, we can take this for disposal.
For disposal, Lordship may keep another day.
21 matter, why another date?
21 matter. My instruction is there is some possibility for amicable solution. Let it come after 2 weeks. In the meantime, let me have the written instruction.
Heard Sri G. Nath, learned counsel for the petitioners. Also heard Miss M. K. Chi, learned counsel for the sole respondent. Full stop. As there was certain confusion on the compliance of the requirement of section 17B of the Industrial Disputes Act 1947, Srinath, the learned counsel for the petitioners, was granted time to obtain instructions, full stop. The learned counsel has however clarified that there appears to be some error in calculation, which however has been rectified, and the balance amount has been released today. Full stop. Ms. M. Kechi, the learned counsel for the sole respondent, submits prays for some time to have the instructions. Full stop. Para. Srinath, the learned counsel for the petitioners, has also submitted that steps are on to have the matter amicably settled. Full stop. In view of such submission, matter is adjourned by 2 weeks. Full stop. Since this matter is pending since since 2021, if no amicable settlement is reached within this period, this court would take up the matter for final disposal at the admission stage on the next date fixed. Full stop. List on 15th of September. Yes.
This case wrongly listed, it should come on motion column. There is a direction to file.
Motion.
Yes, Lord.
You argue for motion, will issue notice.
They've already filed amended cost title by making party Union of India, Department of Revenue. Copy has to also submit. GST metals.
Hereby. What is it? We can issue notice.
Then
What is the matter?
metal also we have challenge and demand notice as well as order passed under section 74 of the GST Act at page number 181.
Mr. Gogoi, you are not there on record.
Yes, sir. I'm not on behalf
On behalf of Mr.
Yes.
Thakur.
Yes,
Okay.
sir. I think it should be adjourned to fire.
You are praying for recovery proceeding also. Stay of the recovery proceeding.
Yes, sir.
There's one fire also.
What is the stage? What is the stage of the recovery proceeding?
Already the impugned order is also 11 November 2025.
No, then no question of recovery is
Lord.
being heard. Sri D. Gogoi Learned Counsel appearing on instruction of Sri S. Thakur, Learned Senior Counsel for the petitioner. Full stop. The grievance is against recovery proceeding initiated by the GST authorities for the financial years 2018-2019, 2019-20 and 2020-21. Full stop. No. Okay, the grievance for the financial year
2024.
No. I don't know. As per the facts projected, recovery proceedings initiated for the financial year are the subject matter of challenge in a writ proceeding already instituted, being WPC 2748 of 2025. Full stop. The present grievance is against a fresh proceeding for the year 2021-22. Full stop. The Learned Counsel has also informed this court that pursuant to earlier orders passed by this court, amended cost title has been filed, which is required in terms of an office order dated 21/7/2026. Put the para. Let notice be issued returnable on 28th, 28/9/2026. Yes, Mr. Barua for 1 2,
All
Three.
the respondents, my lord.
All of the open,
Big
government.
my lord.
not all the six, till 6. H. Borua, learned counsel appearing on instruction of respondent numbers, instruction of 3 B. B. Goel, learned AG accepts notice on behalf of respondent 1, 2, 3, 4, and 6. 5. Superintendent of Police, Bukolial, Secretary Superintendent of Police, State Council, Union of India, CGC. Who's there in the court? Okay, Gogoi. Is he there in the court? For CGC for 7 extra copies. Okay.
But Union of India name maybe.
Deputy LG. Last occasion, my lord, B. Gogo's name was recorded as additional LG, my lord. Okay. For all the respondents.
Then all he can take for this thing also. Superintendent of Police also.
And my lord, the maintainability of the repetition was kept open, my lord.
Why?
Yes, my lord, 4 months has already crossed, my lord, for revocation of GST, my lord. Under statutory provisions, my lord.
Okay, এটা লিখিবা হা এটা দিব কলিয়াল নালাগিবা হা for 1 to 5 বুলি 1 to 6 and 7 is Union of India.
Yes, yes.
7 হেৰি হ'ব কে গগৈ 3 H Barua, the learned counsel has however raised the issue of maintainability of the writ petition. Fourth, the aforesaid issue is kept open.
Diplomas.
These are all blacklisting matters from.
May I please, my lord? My lord, in this case, my lord, the petitioner participated in a tender, my lord.
Will take for final disposal.
Yes,
How long will you take?
will take some time, my lord.
No, sometime we will finish it today, but today we have to rise by around, we have an interview from 3. Half an hour will take maximum
My lord.
and 15 minutes to you.
Yes. Issues are not very
Yes.
complicated.
By 2:30 we'll rise. Okay. Okay. We take which petition first?
My lord, item number 16, that is WPC number 7481.
Grounds are more or less the same.
Almost same, my lord.
Facts are identical.
You want 7481?
7481, my lord.
Okay.
My lord, petitioner participated in a tender, my lord, issued by ONGC, my lord.
7481. 3 petitions are there. Please give a list who is appearing in which petition, okay? Mr. Mishra, one discuss. 7481. Where, yeah, Gupta is appearing here.
Yes, my lord.
Okay.
My lord, in this case,
There is a tender process.
tender was issued on 16/5/2025.
Tender.
Yes, my lord.
NIT.
NIT.
You
Then the-
participated.
Yes, my lord, participated. Then, my lord, his tender was rejected mainly on the ground of cartel, my lord.
Your tender was, or bid was rejected.
Rejected.
Why?
Mainly on the ground of cartel, my lord. That
A
is
cartel was formed.
form, my lord. That is communicated by email dated 2/9/2025.
2/9.
2025.
Email.
That is at 248, my lord.
Page 248.
248.
Then
Then, my lord, the petitioner submitted representation that was not accepted. Then thereafter, my lord, so-called notice issued for blacklisting, my lord. Then at that stage, my lord, the petitioner has approached this honorable court. And this honorable court, while issuing notice, directed to proceed with the process, but not to issue any final order, my lord,
in this proceeding.
in this proceeding. my lord.
Yes.
248 if lordship may take up, my lord.
Blacklisting for how many years?
This so-called notice is issued for a minimum for 6 months, maximum is 3 years, my lord.
Page 248.
248. This is the rejection order, my lord.
Yes.
My lord, may I read, my lord? With reference to the bid submitted against tender number so and so, it is observed that the IP address that is so and so mentioned in the GEPNIC CPP portal is same as of another bidders BK Agarwala, Hitesh Datta, who have also participated in the tender with other similar.
IP address means?
IP address means the computer from the computer or the internet from which the bids were submitted, my lord. These are e-bids, my lord. In view of the above, the offer submitted by you is not acceptable as per BEC clause B.2.4 H2.
These are the petitioners before us. BK Agarwala, Hitesh Datta,
Yes,
and you.
yes, my lord.
Okay.
And my lord, the clause, my lord, that is 2.1 of integrity clause, my lord, that lordship will find at 211, my lord.
Two hundred and
11, my lord.
yes.
2.1.b, my lord.
Two point
1.b.
section 2.
Yes, my lord. Section 2.
Then clause 1, not
Clause,
2.1.
sorry, my lord. Clause 1, then a small b, my lord.
Okay.
The bidder
Section 2, clause 1B.
b, my lord.
Okay.
The
Bidder contractor will not enter that one.
Yes, my lord. The bidder oblique contractor will not enter into any agreement or understanding with other bidders in connection with the bid, including but not limited to prices, specifications, certifications, subsidiary contracts, submission or non-submission of bids or any other actions to restrict the competitiveness or to introduce cartelization in the bidding process.
Yes.
Well, this is the clause, my lord. And my lord, in my writ petition, I have stated in paragraph 11, 12, and 13 the explanation for same IP address, my lord.
That is the only basis of the so-called notice.
Yes,
IP address is the
IP
same.
address and the other some similarities are also there. As
What
per
are the other
Other
similarities?
similarities, my lord, that the one certificate is required from the charter accountant, my lord. That is similar with regard to all these three, my lord. And my lord, the bids submitted while submitting.
Same chartered accountant.
Same charter accountant, my lord. He has issued the certificate to three different persons, my lord. And my lord, while submitting the my lord bid, my lord, the format and the my lord, there are some mistakes that is common to all the three bidders, my lord. My lord, that I have explained, my lord, why these mistakes are on everything has occurred.
Same mistake.
Same mistake.
Wrong answer copied by all.
My lord, what happened, my lord? These all the three bidders unknowingly, my lord, has engaged one, my lord, Durlabh Gogoi. He used to, my lord, submit the bid. Not only this, my lord, have made a categorical statement that from last more than a decade he used to submit the tenders.
But what about the CA certificate?
CA certificate, my lord, CA, I have explained in my reply that, my lord, this is given by CA, my lord. This is Sibsagar district, my lord, and that CA is known to everybody, my lord. And my lord, this petitioner and my lord, BK Agarwal, both are brothers, my lord. This
So family cartel is already there.
family, we have different business establishment. We are doing business, and even earlier also we have participated in the tender, my lord. So only by things the CA, but the certificates are different. And my lord, the thing is that the 100% localization product used or not, that is the issue, my lord. So CA, by going all the documents provided by the petitioner and the other person.
Too much of coincidence.
But my lord, whether will, my lord, form a cartel, my lord, that is my submission, my lord.
No, they are only initiating a show cause notice. They have not blacklisted you.
No, not blacklisted, my lord, but they have filed the alia. They say that, my lord, they have concluded and they will.
Conclusion did not know. Conclusion can be the subject matter of challenge, but can you preclude them from having initiating a process? They have all the rights.
No,
Prima facie, there appears to be materials. Can they be precluded to even to proceed? The culmination may be against you, may not be against you. If it's against you, you have all the rights to challenge it. That these are not relevant consideration. But can you just put a embargo at the threshold?
My lord, my submission is that's why I'm challenging the rejection order, my lord. Although I'm not going to I'm not praying to lordship to revert the clock back, my lord. I'm only challenging the rejection. So far, it's relates to finding, my lord, the cartel.
See, if, the rejection, challenging the rejection and challenging the show cause for blacklisting are two different aspects. Let us see the relief which you have prayed for.
In fact, this aspect has been recorded by your lordship.
Yes,
while issuing notice.
notice, my lord.
That misjoinder of causes of action.
Page 16 is the.
Your lordship will find.
Is it?
Yes,
Your lordship will have a look at the order dated 7/1/20.
Now, Mr. Gupta, you have to make up your mind. What are you challenging?
Then I will confine to, my lord, rejection of my bid.
We thought that you will say, then I'll withdraw the petition.
My lord, I will confine to rejection of my bid, my lord.
Rejection.
Yes.
Rejection, okay. Which order has been rejected? That part?
Notice.
Messenger of cause of action?
7/1/2026.
Which court?
Lord,
this court?
Yes, my
Okay.
lord.
We
Lord,
don't remember.
my lord, lordship has
Or
kept
distinct
open
and
the-
whether considered given Friday. Okay. Okay, we thought these are very big matters. Not take time. Okay, we'll do one thing. We'll sit for some time, but it may not be completed today. Tomorrow we'll complete it. Tomorrow you have to be there.
Tomorrow, my lord, I have to rush to Itanagar. It can be on Friday. Friday I'm available. I'll come back on Thursday.
Friday.
My lord,
Well,
Friday.
tomorrow.
But we may finish it also before your lordship rises because the points involved are very short.
Now, today and tomorrow we have an interview. If we can finish the interview today itself, we can sit till tomorrow. But in that case, we'll have it on Friday. We'll make it parted.
Fine.
But Friday will be the last day of this court. This court will also be not be available.
Friday.
But we can finish it. No problem.
I think it can be over within half an hour.
Okay.
The points involved are very short.
Okay, let us try. 2 o'clock will sit. We've almost understood your case.
My business lordship, item number 10. It will be fixed by
10 is of which year?
2016.
16. We'll have it. 16 matter immediately. Purana matter basi time na immediately. Okay.
My lord,
We might do one thing. We might hear you on Friday also. We'll complete Mr. Gupta. Let us see how he proceeds.
my lord, in paragraph 11, 12, and 13, I have stated the reason that why there are similarities.
Mr. Roy, your matter, though we thought of taking, may not be possible today. But we will not adjourn for a long time. Maybe day after tomorrow we'll try. Those are all matters, 16 matters. Some.
Day after Friday, a short matter, just 1 minute time. It will
Okay, we'll come, but not beyond this
no,
week.
no.
16 matters, all matters, no adjournments. Okay. But we'll give a date. Okay, today will not be possible. We have some interview. We have to rise early. Okay.
Friday, my lord.
Okay. Friday, yes, Mr. Gupta.
My lord, in paragraph 11, 12, and 13,
Of?
the writ petition, my lord, page 11, my lord,
You were sticking on your termination
on a decision
to reject your bid.
my bid as well as forfeiture of EMD, my lord.
Hmm?
As well as forfeiture of EMD, my lord.
And that is a consequential thing, but not this aspect of blacklisting. It's a separate cause of action. Okay.
Page 11, paragraph 11 of the writ petition, my lord.
Writ petitions are also identical.
Yes.
Cartel keeps on, huh? We have to break the cartel at some stage. Paragraphs are also identical. Wrong strategy.
Even the commas and full stop.
Okay.
Paragraph 11, my lord. that-
11, at page 11,
Yes,
yes.
my lord, that the petitioner states that one Sri Durlabh Gogoi, son of Sri so-and-so, resident of so-and-so, Sibsagar, Assam, who has expertise in submitting of online e-tenders of all department, including ONGCL. He has been providing the aforesaid services from his establishment, apart from providing other online services. That the petitioner states that the petitioner has appointed the said Sri Durlabh Gogoi for submitting his online bids. And since then, the petitioner has been submitting his online bids through Sri Durlabh Gogoi only. And then, my lord, paragraph 13, I have stated that more than a decade, that the petitioner stated that it has been
13.
13, 1-3, my lord. That the petitioner states that it has been more than a decade, the said Durlabh Gogoi has been submitting the petitioner's online bid.
Okay.
Then, my lord, in the affidavit in opposition filed by ONGC, my lord, the similarities, what are the, say that page 262, my lord.
262.
Yes, my lord.
Yes.
Paragraph 17, my lord.
Part of 17.
Yes, it is
263 is a continuation.
continuation, my lord. First,
No,
I'm-
it's, 70 or 17, yes.
yes, my lord, there are number of similar, my lord. First one is IP address, my lord. I'm not reading the whole, my lord. First paragraph says, my lord, IP address.
Yes.
My lord, second paragraph, charter accountant certificate.
Yes.
My lord, third paragraph, my lord, it states about appendices BP1, BP2, and BP3. Reveals that the bidders have filled the said appendices in identical manner.
Yes.
Then fourth is also identical. Then, my lord, fifth is important for this petitioner, my lord.
What is fourth?
Fourth is, my lord, appendix GU. All the bidders have adopted an identical and unusual mode of submission.
Five.
Five, my lord, that there is connection between the petitioner, this writ petitioner, and BK Agarwala. My lord, in this cases, it is said that both the person's father's name as well as the address is same, my lord.
Petitioner in this case is whom?
Gopal Agarwala, my lord.
Gopal and
Gopal Agarwala.
Mrs. BK.
BK is different, my lord. Both item number 18.
No, petitioner in this case is Gopal and BK Agarwal is another petitioner.
Another petitioner. Both are brothers, my lord.
Mrs. BK. BK is another petitioner.
Yes, my lord. Item number 18.
Vijay Kumar.
Vijay
That
Kumar.
is WPC 114.
My lord.
Okay.
My lord, these are the mainly similarities due to which the authority come to a finding that there is cartel. My lord, my explanation, lordship may kindly come to page 328. Affidavit in reply filed by the petitioner, my lord. Page 328.
Yes.
My lord, paragraph 9.
para 9.
Yes, my lord. Sir, certificate of deposit, page number 328. Page 328, my lord.
Yes.
I'm reading from A, my lord.
Hmm.
It is submitted that the petitioner, like many other small and medium scale contractors in the Sibsagar district, is not technically proficient in the complexities of the e-tendering process. Consequently, for many years, the petitioner has availed the professional services of one Sri Durlabh Gogoi, who runs a facility of preparing and uploading e-tenders for various government departments, including the respondent ONGC. This is a common and prevalent practice in the region, born out of necessity due to lack of in-house technical infrastructure and expertise among local contractors. The use of the petitioner's digital signature certificate by the said Durlabh Gogoi is a standard operational procedure for such service providers to upload bids on behalf of their clients and does not in any manner absolve the agent of his professional responsibility or impute a collegiate mindset to the petitioner. The petitioner has absolutely no knowledge that two other bidders, namely Sri Gopal Agarwal and Sri Hitesh Datta, has also independently engaged the service of same individual Sri Durlabh Gogoi for the submission of their bids for the same tender. The fact that all three bids were uploaded from the IP address so-and-so is a direct and natural consequences of the bids being uploaded from the same service provider's establishment. It is a mere technical coincidence and cannot agreement or understanding between the bidders to restrict competition. The respondents have failed to appreciate this ground reality and have irrationally jumped to the conclusion of cartelization. The alleged similarities cited by the respondent are all attributable to the common third party service provider and not to any collision
Okay,
between
this I have got. Then
Then, my lord, E is, my lord, the identical deficiencies such as the failure to submit self-certified MII certificates, etc. are telltale signs of a common preparer, Sri Durlabh Gogoi, using a simple template, my lord. Then, my lord, CS certificate explanation is at F, my lord. The fact that all the three bidders obtained their CS certificate, MIA certificate from the same chartered accountant, Mr. So-and-so, is also a matter of coincidence. The said firm is a well-known and reputed firm in Sibsagar, and it is a natural for multiple local businessmen to avail its services and cannot be construed as a warning sign of bid rigging. Then, my lord, with regard to Gopal Agarwal and this Vijay Kumar Agarwal are brothers, it is stated that both are the brothers, but they have separate, my lord, business establishments, my lord.
yes.
So these are my explanations, my lord. And my lord, the lordship may kindly consider altogether 30 bidders have participated, my lord. 30, my lord.
Hmm.
And my lord, the nature of work is that it should be either the bidder can quote for 16% or for 20% of the total job, my lord. So not a 1% or 2% is going to get the job, my lord. Either 16% or 20%. Here in this case, the petitioner has quoted, my lord, 16%, my lord.
All the petitioners or your clients.
My in this my client-
Others 16%.
So the similarities, my lord, with that occurred since the same person has uploaded, and these are e-tenders, my lord. So these persons do not know the, my lord, technicalities, so they have engaged a third person to do their work on their behalf. That's why, my lord, these similarities have occurred, my lord. And the certificate, my lord, same CA has issued. That's why the certificate. And my lord, in this regard, I want to rely on two judgments, my lord.
Yes, please.
First one, AIR online. Online. 2026. Gauhati, 19. Well, the first one.
Yes.
The
Which one?
first one I'm relying on AIR online 2026 Gauhati 19, my lord. Messrs. Versa Technotrade Private Limited. In this case, my lord, the plea was taken that there are two bidders who inspected the site, my lord, jointly, and they took the photographs. So there is allegation of cartel was brought in, my lord. In paragraph 23, my lord, paragraph 23, my lord.
Yes.
Even if the altered argument is taken into consideration that the two representatives of the respondent number 3 and 4 were found to have featured in the common photograph, the same in the considered opinion of this court cannot be construed to be any violation of the integrity commitment. To accept such submission would be far-fetched and would be in the realm of imagination unless any concrete materials can be demonstrated. This court would be loath in interfering with the matters pertaining to allotment of contracts. This court has also taken into consideration that site visit by the respective bidders was a mandatory requirement and there is no stipulation that such visit cannot be made on the same date or time by different bidders. This court is also unable to accept the submission that only because the respondent number 3 and 4 were found to be bidders in various other contracts, a cartel can be presumed. Rather, a contrary view would be also be possible that there is competition between the respondent number 3 and 4. In another judgment.
But what was the basis here? The site visit was found to be made on the same day.
Same day, and both the persons had there are photographs to show. The case is made out by the petitioner that since both the persons have visited together and there are photographs to show, so therefore there is allegation of cartel malice. So the lordship felt that, my lord, only by showing the photographs and visiting the site together will not one do some concrete is required, my lord.
Okay.
And, my lord, the other judgment is of Bombay High Court, my lord. My lord, here I am relying on paragraph 7, 11, 29.
And this name MS GH Andelwala. A paragraph?
7, 11, 29, 48, 49, and 50, man.
7, 11, 29, 48.
49, and 50.
Yes.
My lord, paragraph 7, if lordship may take up, my lord, at page 5.
Yes.
It is contended that respondent number 4 and 5, who are son and father, respectively, have participated in the bidding process as separate bidders, while relying upon substantially common machinery, resources, and infrastructure, thereby forming a single economic unit. Such participation, according to the petitioner, is collusive in nature, amounts to cartelization, and defeats the requirement of genuine and fair competition in the tender process. These are the facts, my lord. Then lordship may come to paragraph 11, my lord.
Yes.
It is further submitted that both the respondent number 4 and 5 have uploaded documents reflecting common ownership and control, including identical business addresses, overlapping machineries, and a list of common technical personnel. Additionally, respondent number 5, so-and-so project has executed a hire agreement of machinery with another party, namely so-and-so respondent number 4 for use of machinery, which further evidence collusive practices and undermines the fairness of tender process. Certain documents, including undertakings, indicate interdependence between the two entities, thereby undermining their status as independent bidders. Then lordship may come to paragraph 29. Page 11, madam. With regard to allegation of cartelization, it is submitted that respondent number 4 and 5, though related, are independent contractors carrying on separate proprietary business. In the absence of.
These are
any-
the submissions. Let us see the findings.
Finding at page 48, 49 and 50, my lord. I'm reading from paragraph 47, my lord.
Hmm.
The learned senior counsel for the petitioner has also alleged cartelization on the ground that respondent number 4 and 5 are related as son and father and had participated in the same tender. While cartelization is a serious allegation that strikes at the root of fair competition, the same must be substantiated by cognate and credible material. Mere relationship between bidders cannot be an inference of collusion. What is requirement to establish in such a case is that the tendering authority has abused its dominance or that the competent bidders is ousted as a result of anti-competitive practices. None of these to the prejudice of the petitioner is evident in the present case. Upon scrutiny, the contention does not sustain. The allegation of cartelization is based primarily on relationship between the respondent number 4 and 5 and certain similarities in the documents submitted by them. However, it is not in dispute that both respondents are independently registered contractors and have participated in the tender process in their individual capacities. The tender document does not prohibit participation by related entities in the absence of any material to demonstrate bid rigging, price manipulation, or lack of independent decision making. The allegation of cartelization remain unsubstantiated. So in my case also, my lord, although, my lord, that we are brothers, we have separate, my lord, business establishments, separate, my lord, licenses and contracts, everything, my lord. And my lord, there is no allegation that there is price rigging or something, my lord. So the mayor, my lord, the coincidence that there is.
Where your price bids opened?
No,
Not open.
not open, no.
The
Technical bid rejected.
rejection is at the technical
Technical
evaluation stage only.
Yes, ma'am.
That it appears that a cartel has been formed by all the three petitioners before us,
Ma'am.
and therefore the bids have been rejected on that ground.
Ma'am.
Okay.
So my submission is that, my lord, there is nothing to show that there is a price rigging or anything to concrete to show. The decision of the authority is, my lord, not right, and that may be interfered with.
What is the meaning by bid rigging and price manipulation?
My lord, what I understand, price manipulation means suppose the prices are matched or something like that, my lord.
Now you have to be very specific. We do not know your price bids. See, there are no other materials on which your bid has been held to be technically non-responsive. This is the only ground. So if you are able to pass the threshold and considered for financial bids, the manifestation, whether there is a cartel or not, will be shown then. What are your price bids? You must be having your, what is the price quoted? You must be having the instructions.
But I do not have the exact price, ma'am.
Huh?
I do not, at present, I do not have the price, ma'am. What price is quoted?
How is the price rigging done? Bid rigging?
If there is some understanding between the bidders, my lord.
No, that is the basic thing, concept. But how is the actual process? How is the actual dynamics carried out? You show a competition between yourself and you want one person to get the contract. That is the main primary objective, that you have more than one bidder who are in collusion. Somebody will bid a lesser amount and ultimately one amongst you will get the job. That is what is done.
But in this case, my lord.
No, that not your case.
Yes.
That the price bids are given in a manner that one amongst yourself will get the job. That is the concept. And how many bidders were there in total?
30, 30.
30 bidders.
30.
And 3 of you have been disqualified.
Disqualified.
Oh.
So some others are also disqualified, my lord.
In fact, we found that there was a cartelization amongst 14 bidders. The others have not come before this honorable court. These are the 3 who are before you. And I'll point out.
They are bold. They want to assert their rights. Mr. Chaudhary will hear you on Friday.
My lord, can it be on Thursday or on
Thursday,
Monday?
your senior colleague is
Then
not
on
there.
Monday, my lord. Friday we have.
Monday, this court will not be there.
Then some.
You have to come to Itanagar. We'll be very happy to hear you at Itanagar.
I would also like it.
He is also agreeable. You come over, we'll have the records transferred to Itanagar.
On the Friday, we have some difficulty.
Your part is over. If there is need, Mr. Mishra will reply.
Otherwise, you would not have said so much.
If you say Rakhi, even Mr. Chaudhary will run home for other reasons. Rakhi calling. Not only you. What to do? Tomorrow? Is it possible?
Tomorrow, my lord, I have to.
Day after?
Day after, I will not reach back because tomorrow I have something which is totally unavoidable. And day after, my lord, there are some matters, 2 matters fixed from long back.
You tell us, we don't want to believe this like this. We have already heard.
Or else, my lord, your lordship may keep it on immediately as when you
No, that we don't keep part-heard matters like this after 2 weeks. Part-heard means tomorrow, day after tomorrow, or the same week. From 31st till 11th, this court will not be here. We will hardly require 15 minutes of yours.
I will not take more than that. Or else, my lord, let me do my part on Friday. They can always have, nowadays they can watch it online also if they want. And
If you want to join online, you will be allowed to join online. Is it possible?
I can try, my lord.
Yeah, then we can reserve it for judgment. Okay? Right. Tomorrow we would have accommodated. Tomorrow also we have an interview. We'll rise early, but nonetheless. The learned counsel for the petitioners have advanced their arguments full stop. For paucity of time, comma, this court could not hear the arguments to be advanced by Sri I. Chaudhary, Learned Senior Counsel appearing for the ONGC. Full stop. On request, list on Friday for further hearing.
I would like to add some arguments, my lordship.
On Friday, yes.
My
Yes, sir. You will be entitled to make a rejoinder. In your rejoinder, you can incorporate everything. We have not made up any mind. You have cited certain reasons. We'll examine those reasons. Place like Shivsagar going to one service provider is not unnatural. But we'll look into other aspects. Even same CA may be a thing. But we'll see to look into the other aspects. Ekon Friday ahibo, ha? Etate thojle hole. Eto Friday. Okay. Rest date.